This video takes you inside two explosive courtroom encounters where so-called sovereign citizens come face to face with reality, and it does not go how they expect. What begins as confidence and defiance quickly turns into confusion, frustration, and legal trouble as judges calmly dismantle every pseudo-legal argument thrown at them. In the first case, a man refuses to acknowledge his own name, insisting the court must decide whether it's speaking to a flesh and blood man or a fictional legal entity. He waves around paperwork, claims ownership over his identity, and argues that the court has no authority over him. The judge, unbothered and almost amused, patiently explains the law while making it clear that these arguments carry no weight. With the defendant refusing to answer even the simplest questions, the hearing comes to a halt, showing how these tactics only delay the inevitable. The second case raises the tension even higher. A woman facing a basic traffic violation attempts to derail the hearing using universal law, repeatedly claiming she does not understand the charges, because, according to her, understanding would somehow give the court power over her. She interrupts the judge, talks over her own attorney, and rejects a deal that could have easily resolved the case. Instead of walking away with a minor penalty, her behavior pushes the court toward harsher consequences. Together, these hearings reveal a hard truth: sovereign citizen arguments may sound confident, but in a real courtroom, they collapse fast. Judges have heard it all before, and patience has limits. What you're about to watch is a perfect example of how courtroom defiance turns into courtroom disaster.
Oh, hold on. Mr. Strickland? Mr. Strickland, can you hear me?
This is the judge.
Okay. Mr. Strickland!
Open the door.
Can you hear me?
Can you hear me?
You don't want to hear me.
Sir, can you hear me? What?
Mr. Strickland, this is Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with? The name entity or the flesh and blood man?
You tell me.
I demand to be released on my own recognizance. I have a UCC1 here. I've laid claim to the name entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State.
Okay. Sir?
It's right here, Lincoln. To the flesh and blood man or the name entity.
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that? Now, sir, I know you want me to release you.
Here it is.
Are you gonna let me talk?
Here.
Are you gonna let me talk? Sir?
Sir?
Are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down, sir.
Don't consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right. Now,
For UCC one, everything.
if you don't, when I talk, you listen.
I am.
If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand that?
But we already been through this. I am the executive of the account.
Okay. Have a good day, sir.
Ms. Phillips, please state your name.
Shannon Phillips, the natural woman. On the
Okay,
record and for the record, and let the record reflect. Can you guys hear me?
Very
It's
loudly.
saying I have an unstable connection. Okay. Just making sure.
So on October 9th, defendant was found in contempt of court. So that still stands. Ma'am, you can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
Was never let in, just like now. You administering the trust without consent?
I'm not going to be.
I'm having a bad connection. It's going in
I'm
and out. I'm not hearing nothing you
releasing the
all are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't need a public defender, Judge Washington.
Ma'am, I asked you a simple question and you did not answer the question in a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is
the charges.
You cannot make me have an attorney.
Well, actually I can, ma'am.
Like, this is insane.
Well, I don't think it's me.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction and expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Right. I will let you do that.
Thank you, Your Honor.
You're welcome.
Assistant Public Defender Davi Liebe on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
Shannon Phillips, the natural woman.
Lebo, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney. Additionally, indicated to me that she is not, at this time, wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, criminal infraction. Okay. So, Ms. Phillips, that's correct. You're rejecting that offer.
The offer of what? He didn't offer anything.
Ms. Phillips, he just told you that he's offering.
Am I not hearing something?
He just told you that he's offering you the civil infraction of expired plate as opposed to the criminal offense of expired plate. One carries
Okay,
a
but according to the Supreme Court, traffic infractions are not a crime. The People versus Battle. So what criminal infraction? And I would just like for the case to be dismissed. One, because your who was it, Officer Hannah, and 3 more officers were surrounding my vehicle, pulling my door handles, threatening to pull me out of my vehicle.
Ms. Phillips, I'm going to advise
I don't
that you
even
not
have the
discuss this.
vehicle.
Phillips. I'll take that as a rejection of the offer.
Okay, so what's the offer?
I'm
I
not
didn't
going to
tell
keep
him
going in
anything.
circles with you, ma'am. Mr. Lebo.
Right, y'all just hate to hear the truth. Y'all just want to do what y'all want to do.
Ma'am, if you don't stop yelling out in court, you've already been held in contempt before. I'm going to hold you in contempt and give you 10 days in jail. Do you understand? Mr. Lebo, do you know what your client would want to do?
I do not, Your Honor. I did have a discussion with her, but she did not convey to me desire to participate in that conversation.
All right. Then if she's not telling you, I will set it for a trial date.
Ms. Phillips, Your Honor, I would perhaps ask the court to consider a competency referral.
Nothing is wrong with me, you all. I am perfectly fine. I can handle my own affairs. Nothing is wrong with me.
I see you're doing so well so far. You're almost going to jail on a traffic offense.
And I do want to know that I did attempt to explain to Ms. Phillips why her understanding of the case law regarding traffic offenses was inaccurate, but that was not a productive conversation.
I could see why it wasn't productive. So I don't know that she meets the level of incompetence to the standard that you're indicating. That if you want a referral because you've talked to her and that's where you are, I will refer her for a competency. If she doesn't participate in that, then she'll be found in contempt or have to go to jail to get it done. So her behavior here today is obviously taking her down a very dark path. Hopefully she can change her mind and do something appropriate. So you either want to have a trial, ma'am, or you want to actually accept an offer. So those are your options.
We could take it to trial. We can take a trial.
This video brings together 2 courtroom encounters that perfectly expose how so-called sovereign citizen arguments collapse the moment they face real judicial authority. These hearings aren't just about traffic tickets or procedural delays. They're about individuals who believe that refusing to recognize the law somehow places them above it. What unfolds instead is a slow, undeniable breakdown of those beliefs under calm but firm judicial scrutiny. From the very beginning of the first hearing, tension fills the courtroom. The defendant refuses to answer the most basic question, his name. Instead, he insists the judge clarify whether he is speaking to a flesh and blood man or a separate legal entity created by the government. This distinction is central to sovereign citizen ideology. The belief is that the name printed on documents represents a corporate entity, while the real person exists outside the reach of the law. But the court doesn't operate on beliefs, it operates on facts and jurisdiction. The judge listens patiently as the defendant speaks in circles, repeating the same phrases with increasing confidence. He claims to be the executor, or executive, of the name entity, asserting that because of this role, the court lacks authority over him. He references UCC filings as if they were magical documents capable of overriding criminal law. What's remarkable is not the argument itself. Judges hear these claims all the time, but the judge's response. There is no anger, no raised voice, no visible frustration. Instead, there is calm, steady clarification that none of this has legal meaning in a criminal courtroom. As the exchange continues, it becomes clear that the defendant is not interested in understanding the process. Every explanation is met with another scripted response. Every question is redirected back to the same imaginary legal framework. The judge even injects humor at one point, joking that he's speaking to both of y'all at the same time, subtly highlighting how absurd the distinction sounds in a real court of law. The moment lands softly, but the message is firm. The court recognizes one person, not a legal fantasy. Despite repeated attempts to move the hearing forward, the defendant refuses to cooperate. He will not confirm his identity. He will not answer procedural questions. He will not engage in the process required to resolve the case. And that's the key lesson here. Sovereign citizen tactics don't defeat the system. They stall it. They delay the inevitable while increasing risk. With no progress possible, the judge postpones the hearing, making it clear that the law will still be there tomorrow, regardless of how many times it's denied today. The second hearing shifts the tone from passive resistance to outright disruption. This case involves a woman facing a straightforward traffic issue: expired license plates. Under normal circumstances, the matter would take only minutes to resolve. But instead of addressing the issue, she launches into a stream of pseudo-legal language, insisting that she only recognizes universal law. She repeatedly claims that she does not understand the charges, not because they're unclear, but because acknowledging them would allegedly give the court authority over her. This tactic is deliberate. In sovereign citizen circles, refusing to say, "I understand," is treated as a shield, as if comprehension itself forms a binding contract. The judge tries again and again to clarify that understanding the charges has nothing to do with consent. The law applies whether someone agrees with it or not. But the defendant refuses to engage honestly, interrupting the judge, talking over him, and redirecting every question into another monologue. What makes the situation more serious is that she has already been found in contempt previously. The court's patience is not unlimited, and her behavior makes that clear. Even with a court-appointed attorney present, someone whose sole purpose is to help her navigate the system, she refuses to listen. She talks over him, dismisses his advice, and insists she knows better. The irony is painful. The very system she claims has no authority is offering her guidance and protection, and she rejects it entirely. At one point, the judge offers a favorable resolution. The charge could be handled as a civil infraction rather than a criminal matter. This is a gift, a chance to resolve the issue quickly with minimal consequences. But instead of accepting it, she refuses, citing obscure case law and arguing that traffic violations aren't real crimes. This moment perfectly captures the danger of misinformation. A minor issue that could have ended peacefully is now spiraling into something far more serious. As the hearing continues, her volume rises. Her interruptions become more frequent. The judge is forced to repeatedly remind her of courtroom procedure. The focus slowly shifts away from the traffic ticket and toward her behavior itself. The question is no longer about expired plates, it's about whether she is capable of participating meaningfully in her own defense. Eventually, the judge discusses setting the case for a jury trial and raises the possibility of a competency evaluation. This isn't an insult, it's a legal safeguard. When someone refuses to engage with reality to this extent, the court must consider whether they understand the consequences of their actions. And that is the real turning point. What started as defiance has now triggered deeper legal scrutiny. Taken together, these two hearings reveal the same underlying truth. Sovereign citizen arguments rely on repetition, confidence, and the illusion of hidden knowledge. But courts are not arenas for philosophy or personal belief. They operate on law, precedent, and jurisdiction. No amount of paperwork, wordplay, or refusal changes that. Zoom courtrooms may give the illusion of distance and safety, encouraging some defendants to act more boldly than they would in person. But the authority of the court doesn't weaken through a screen. If anything, these cases show how quickly defiance can backfire when patience runs out. What you're watching isn't the law being challenged, it's the law being tested and reaffirmed. And in every instance, reality wins.